All right.
Okay. Hello, everyone, and welcome. My name is Laura Cohen. I am on the clinical faculty here at Rutgers Law School, and I also direct the Center on Criminal Justice, Youth Rights, and Race. I'm so thrilled that you're all with us today, although so very sad and troubled about the reason we're all here together today. As many of you know, on February 1st of this year, after a landslide re-election for Aung San Suu Kyi and her National League for Democracy, the Myanmar military seized control of the government, incarcerated the state councilor and many of the leaders of the Myanmar lawfully elected government, and has proceeded to violently quash an organic and important and in many ways unprecedented protest movement that has arisen in the streets and across the country. We are joined today by two eminent speakers who have spent time in and thought closely and carefully about not just the Myanmar government, but also the continuing genocide and expulsion of the Rohingya people and other ethnic minorities in Myanmar, to educate us about this, this tragic and still unfolding situation, and to help us map out what is actually happening on the ground there. Before I introduce them and before we start, I first of all want to thank the incomparable Habiba Johnson, who helped us put this program together today and is handling all the tech, and the two equally incomparable center fellows, Rutgers 3L's Mary Claire Patterson and Jennifer Monhay, for all the work that they have done to put this program together. So we're going to start with a short video clip that is going to give us a framework and a visual for what is happening in Myanmar, and then turn it over to our two speakers. Habiba, could you please play the clip? Habiba, I think you need to share your sound as well as your screen.
Warning that anyone hiding protesters would also. The campaign of intimidation in Yangon, hundreds of young protesters were trapped after they were surrounded by police and Myanmar's military in the city's San Chao district. Threatening door-to-door searches, they fired guns and used stun grenades as they patrolled, warning that anyone hiding protesters would also be punished. It lasted all night. The protesters were finally able to leave in the early morning hours after the security forces pulled out. In a rare and risky nighttime gathering, protesters in Yangon broke curfew, went to the streets calling for the release of the others. There are reports at least 24 were arrested overnight. Unfazed by the heavy hand of the security forces, across the country, protesters came out and faced the continued crackdown. Just a few hours after the trapped protesters in Yangon were finally able to leave. Since the February 1st coup, an advocacy group estimates 1,800 people have been detained. Several lawyers have stationed themselves in front of insane prison, helping relatives of those arrested find out if they are inside and if they need a lawyer. They say they are dedicated to serving those who have been detained free of charge, but also getting information to the families.
We are not afraid of people threatening us because we are doing this in accordance with the law. And if they do threaten us, it's illegal. We are prepared to carry out our duty until the end.
In nearby Malaysia, a court has given rights groups Amnesty International and Asylum Access the right to challenge the deportation of Myanmar nationals. A big step in the country because its laws often make it difficult to challenge immigration decisions in court. 1,086 citizens were sent back to Myanmar on February 23rd. It's unlikely they will return to Malaysia, but it will prevent more than 100 others from being deported. The next hearing is in 2 weeks. While it's clear Myanmar security forces plan to continue their crackdown, the protesters are also not backing down on the streets, coming out to continue putting pressure on the junta. Scott Heidler, Al Jazeera.
This is the checkers game where grandson and granddad will bond.
So that's just a short overview of what is happening on the ground. To date, over 50 people have been killed by the military forces during these protests, and the violence and the suppression continue in all kinds of ways. I had the good fortune to spend part of the spring semester of last year in Myanmar working with and for the International Legal Foundation, a wonderful organization that helps build systems of indigent public defense in countries around the world. And it was my great privilege in working there to be under the tutelage of Holly Hobart, who has been a public defender and a human rights activist and warrior for a number of years. She began her career after researching women's participation in politics in Turkey on a Fulbright grant, and thereafter went to the City University of New York Law School, CUNY Law School, and quickly developed an affinity for indigent criminal defense. She has been with ILF since 2016, where she assists in developing proactive and effective defense lawyers in Myanmar, Afghanistan, Nepal, Palestine, and Tunisia. And as she does that, also works to build more effective indigent defense systems there. Polly has an LLM cum laude in international crime and justice from the United Nations Interregional Crime and Justice Research Institute in Turin, Italy. She was a public defender for 4 years in New York, and before attending CUNY, she graduated with honors in East Asian Studies from Yale. And so we're going to begin with Holly, and then when we move on to Professor Abdelkader, we'll introduce her. Holly?
Great, thanks, Laura, and thanks so much for having me. Really kudos to you and all of your team for getting this together. I'm really honored to be here speaking about Myanmar today. So I thought I'd just sort of start with what I hope will be a brief kind of historical overview that gets us to current context. So as most of you probably know, and maybe some of you don't, Myanmar was formerly known as Burma. Right, Burma was the name of the country under British colonial rule, and it was sort of post-independence that it became known again as its native name of Myanmar. And not much longer after independence, which really was led by a general of the name Aung San, who is the father of Aung San Suu Kyi, and so that name and that family obviously plays some big importance in the history of Myanmar. But not long after independence, the military actually took over through a coup and launched what ended up being a nearly 50-year really closed off period of authoritarianism, military dictatorship, at which point Myanmar was cut off from the entire world. And it was then in 1988 that there was a big student-led and kind of activist-led uprising, and Aung San Suu Kyi was a big leader in that movement, And it was in that uprising or as a result of that uprising, that she was then arrested and ended up being placed under house arrest. So the military dictatorship is continuing up through really up through till the early 2000s, at which point there started to be some opening up to the international, to the world. And it was in 2008 that the Myanmar Constitution was drafted and passed. So this is the current constitution that Myanmar is operating under. It's certainly, a big step forward from total authoritarian rule, but the military does retain a lot of authority under the Constitution. So there are a couple of big points. One is that there's a quota for seats in Parliament for military officials. It's a 25% quota, so they have to have that presence in Parliament. Additionally, they have heads of certain ministries, including the Ministry of Home Affairs, and they also, Myanmar has 2 vice presidents under the Constitution, and the military appoints one of those vice presidents, and put a pin in that because that will become important later on as well. So, since 2008 and the introduction of this new constitution, there have certainly been some positive developments, and there have also been some not so positive developments, and Angie will be speaking more to some of those problems after me. But for the most part during that time, and since 2008, the party of Aung San Suu Kyi, the National League for Democracy, the NLD, has basically won sweeping, swept elections, has controlled the government, to a very large extent. Also really one of the kind of issues with the strength of this sort of burgeoning Myanmar democracy. And that then sort of, fast forward to 2020, there was an election. The most recent election was in November of 2020, shortly after the US election. And, I was asked to kind of point out some of the reasons for the coup. I think I don't necessarily have all the answers. I mean, some of my personal opinions as to why, there's a general, the General Min Hlang, who has been, a prominent military general for some time. It's been reported that he really, wanted to be president before, before his time was done. I think that there's some Trump era context here happening as well. The military basically justified their takeover on the basis of quote unquote stolen and fraudulent election, that the results of the election were illegitimate, and that justified their actions. Whether or not this would have happened, had what happened in the US not happened, I don't know. There's also a lot of support from China for Myanmar, and that plays into this equation as well. And you know, some of you may know about kind of there's been a lot of regional you know, regional movement as well towards authoritarianism, you know, seeing similar things in Thailand, in Cambodia, you know, amongst others, China, obviously, as well. And so on February 1st, the military issued a emergency order, and basically after arresting and detaining the president, they said that their appointed vice president, you know, then became the president, and that it was under that president's order that there was a state of emergency that was going into effect for 1 year, and that was effectively the start of the junta. So that's a brief brief summary of where we're at now, and a little bit of how we got here. You know, I did want to next turn to this sort of positive developments that I alluded to earlier, you know, particularly around rule of law development and access to justice issues. In particular, in relation to the work that I do and that the ILF does, you know, one of the big developments was the passage of the 2016 legal aid law. And so prior to 2016, people were only eligible for the assistance of free counsel on capital cases, so only on death penalty cases. But with the new law in 2016, it greatly expanded eligibility in terms of who was eligible for legal aid. There were also some really strong developments in that law in introducing early access to justice principles. So, you know, whereas prior to this law, there really was no inroad or no access for defense counsel to get to criminal cases early on in the case and during the investigation period. So we're talking, you know, weeks, sometimes, if not months before that somebody is detained and before there's even a recognized role of a defense lawyer. So there were some changes in the legal aid law that came with that, in terms of recognizing the importance and the role of defense lawyers during the early stages of the case. Another really positive development came with the introduction of the child rights law. And so this was a new law amending, really revising and updating a previous child rights law that was on the books. But a couple of big advances in that law. One was the age of criminal responsibility was raised from age 8 to age 10. 10 is still super low, you know, as some of you may know, you know, the Convention on the Rights of the Child really supports a minimum age of responsibility at 12. So 10 is obviously better than 8, but you know, it's not yet 12. Anyways, there was also the introduction of the concept of diversion. So the notion about sort of keeping kids out of the criminal justice system. Also, linking kids to services, rehabilitation, to not only keep them out of detention and a real sort of increase of traumatization, but also trying to keep them out and not have them come back into the system. So a brand new concept for Myanmar in terms of the idea of diversion. And that's, I think, that's where ILF comes in. So ILF, we are, as Laura said, working to help build and establish criminal legal aid offices in Myanmar and in the other countries where we work, and build capacity of lawyers to actually fight for implementation of these laws, right? So you have new laws on the books, or rights that are enshrined on old laws, but the real question is about implementation of those laws. And so we are now working in 5 offices across the country. We have about 30 staff, and they're working to get to cases early and to litigate and fight for pretrial release, get kids diverted from the system. We're representing anybody who's eligible. I'm proud to say that our lawyers there are some of the first lawyers to really be providing quality legal counsel to the most marginalized and the most vulnerable. We've been litigating cases of Rohingya migrants who have been just swept up and incarcerated and really had their rights violated at every step of the way in terms of equal protection of the law and any kind of due process of law. And so, now I think getting to where we are today, the real issue, as you saw in the Al Jazeera clip, is that with the introduction of kind of really broad treason crimes and this idea that that the military can arrest people for anything that they see as potentially contrary or challenging their ability to carry out their basic defense services and their basic government administration can actually be interpreted as a crime. So the actual provision of legal aid has become a very politicized and a very dangerous undertaking. And the idea that challenging an arrest or challenging the prosecution of somebody based on a lack of evidence or or any other host of reasons may actually be putting some of the legal aid lawyers at risk. And so I would say all of these lawyers who are getting up on recording, really sort of standing up and not backing down about it, are doing so, are very brave and very courageous. They're doing so at great risk to themselves, and it's been a very challenging situation in terms of still getting to cases, providing cases, doing that safely and securely. Just in sort of closing, I'll say one other real challenge has been the introduction of these new cybersecurity laws. I mean, really, and you know, they're the opposite of security laws. But so, you know, the firewalls that are going up, the amount of surveillance that's happening in terms of you know, the government, and so it's really hard to have any kind of communications, you know, with staff, definitely from here to there. It's hard, you know, for them to safely communicate with each other, with clients. And, you know, there have definitely been instances of targeting. So even just getting out, you know, kind of names and numbers of lawyers who are willing to represent people, you know, that is a challenge in and of itself. So, you know, there's a lot of work happening on the ground. There's a lot of kind of local organization happening. Lawyers are banding together, finding strength in numbers, trying to, you know, not let any one lawyer really kind of go at anything on their own. Also, I think we're trying to some extent to keep things as non-political as possible, you know, very complicated under the circumstances, but really to just sort of keep as much as possible this idea that what we're doing is just a basic public service, that, you know, it's not about any taking a side or about anyone's political beliefs. And to some extent, I hope that that's helping us a little bit to keep the work going. You know, I can't say enough. It's a dangerous context right now, and people are being really brave. And this is all to say, you know, the situation was not very good even before February 1st, right? So you have to keep in mind, you know, Myanmar was not immune, literally not immune to, you know, the pandemic and court closures and you know, restricted access to detainees. And the situation was pretty tough, you know, before February 1st. And that on top of, you know, not a super strong democracy, a really not a super strong culture of defense. And so, you know, it's really kind of snowballed to where we are now. And yeah, I think we're just all trying to kind of take a deep breath and go back to what, you know, the kind of fundamental ideas behind, you know, the need for legal representation and what defense lawyers are supposed to do. I'll leave it at that.
Thank you so much, Holly. We have a couple of questions in the chat. I'm going to save one for Professor Abdelkader because I think it's more relevant to her talk. But one of the questions that we do have is whether many youth are being arrested for their participation in the protests. And when they are arrested, are they being afforded access to counsel, and are they being prosecuted as youth or as adults?
Yeah, I mean, it's a great question. It's different. We're seeing things happen and unfold differently in different locations. So it's hard to kind of say generally what's happening, but certainly a lot of kids and young people are getting arrested. Thankfully, in most places, they're not being detained. So it's sort of an arrest and release situation, I think, happening in most places. One problem that Myanmar, or challenge that we have is that there isn't a lot of great documentation in terms of age, and there isn't you know, very good science around it either. And obviously everything is happening so quickly now, but you know, people should be, under the law, presumed to be children if there's a question, but I don't think that that's not what's happening sort of in practice. And so there certainly are instances of kids being held. You know, we haven't seen any major major prosecutions of any kids at this point. But the access to counsel issue is just, it's bad across the board. So it's hard to even say, you know, it's hard to know for sure because we can't even get to people.
Thank you. Before we move on to Professor Abdul-Qadir, I just wanted to mention that this program is being sponsored not just by the Center on Criminal Justice, Youth Rights and Race, but also the Center on Transnational Law and the Center on Security, Rights and Race. And so I want to thank my colleagues, Professor Sahar Aziz and Professor Jorge Contese for the marvelous work they do in those two centers, and also for their co-sponsorship of this program today. So at this point, I'd like to turn the program over to NG Abdul-Qadir. Professor Abdul-Qadir is a fellow at the Public Religion Research Institute and German Marshall Fund of the United States. She teaches and writes around religion, race, and gender at the intersection of law, politics, and society, and teaches some courses that I certainly would like to be taking, including racism, xenophobia, and related intolerance, Islam, women, and development, and counterterrorism and democracy. She has published widely, including on the plight of the Rohingya people in Myanmar. Her writing has appeared on CNN, on the HuffPost, in Time, the Christian Science Monitor, and a host of other organizations. She has worked with the United Nations, the State Department, the Organization for Security and Cooperation in Europe, the ABA, and many other organizations. And she holds 2 US law degrees, including a degree from the University of Pennsylvania Law School, from which she graduated with highest honors. Professor Abdul-Qadir.
Thank you so much. It's a pleasure to be here, and I'm so grateful to have an opportunity to contribute to this conversation. To that end, I'd like to thank Rutgers Law School and all the sponsoring centers for making this program possible. Thank you, Laura. My remarks center on historic litigation pending before the World Court, among other international tribunals. But to truly understand the significance of these international legal developments, it's important to highlight the historical context that undergirds it. So while there may be a bit of overlap with Holly's presentation, which I thoroughly enjoyed, I believe it's critical for the purpose of my presentation. The United Nations has consistently characterized the Rohingya population as the world's most persecuted community. Such discrimination taints Burma's legal, political, and social spheres. Prior to the recent coup, Myanmar held itself out to the world as a burgeoning democracy on a path of reform. In my view, however, the human rights status of racial, religious, and ethnic minorities reveals the true character of any democracy, and the plight of the Rohingya people cast a pall on Burmese governance. Public international law notwithstanding, Burmese officials have long subjected Rohingya Muslims to a spectrum of human rights abuses, including denial of citizenship rights, restrictions on religious freedom, forced displacement, gender-based violence, and arbitrary deprivation of life. While abuses are often framed as an ostensible response to Rohingya militancy, official persecution of the ethnic and religious minority groups spans decades. That history is critical to understanding the significance of litigation pending before some of the most important courts in the world today, such as the International Court of Justice and the International Criminal Court in The Hague. Historically, the Burmese viewed the Rohingya as illegal immigrants permitted entry by their former British colonizers, despite the group's pre-colonial ties to the land. This context shapes contemporary Burmese views of the group as quote-unquote foreigners, Bengalis, and even terrorists. Such dehumanizing narratives have helped both private and public actors justify persecution, culminating in the most recent mass atrocity crimes. While the Rohingya can trace their ancestral ties to Burma, at least to the 12th century, they are widely seen as quote-unquote outsiders who benefited from colonial governance. The British ruled Myanmar, then known as Burma, as Holly pointed out, for over a century, beginning with a series of wars in 1824. Colonial policies encouraged migrant labor in order to increase rice cultivation and profits. After claiming independence in 1948, Myanmar's authorities viewed the Rohingya as a threat to nationalist identity. Many in Myanmar saw the Rohingya as having benefited from colonial rule. A nationalist movement and Buddhist religious revival further contributed to the growing hate towards this ethnic and religious minority group. In 1962, just over a decade later, a military coup culminated in a one-party military state where democratic governance was woefully lacking. During the next 60 years of military rule, anti-Rohingya persecution intensified. The authorities continued to view the minority group as a threat to nationalist identity, calling them foreigners the army killed, tortured, and raped. They closed Rohingya social and political organizations. They transferred private Rohingya businesses to the government, debilitating the group financially. The Rohingya also suffered forced labor, arbitrary detention, and physical assaults. In the 1970s and 90s, such atrocities compelled hundreds of thousands of Rohingya to seek refuge in neighboring Bangladesh. Burmese officials exploited such mass migrations as evidence of Rohingya status as foreigners, migrants, and Bengalis. They refused to acknowledge or address the root causes underlying this group's flight. This history of military rule is important for understanding the current implications of the recent coup on the plight of the Rohingya Muslims. This is particularly so since the junta has publicly called for the repatriation of more than 1 million refugees currently in Bangladesh. Should this group return, I dare say their fate looks bleak. In addition to the interpersonal and state-sanctioned violence inflicted upon the Rohingya, it's important to understand the manner in which such discrimination has been codified into law and policy. In 1982, for example, the Citizenship Act of Myanmar denied citizenship to the Rohingya, legally rendering them the world's largest stateless population in violation of public international law. To be sure, Rohingya statelessness facilitates other abuses, both private and public, from restrictions to accessing healthcare and educational opportunities to arbitrary detention and extrajudicial violence. The Rohingya are still classified as illegal immigrants allowed in by their British colonizers. To be sure, Rohingya statelessness or lack of citizenship exacerbates their vulnerability because they are not entitled to any legal protection from the government. More recently, in August of 2015, Myanmar enacted the Protection of Race and Religion laws, a series of 4 discriminatory measures. For instance, the Buddhist Women's Special Marriage Bill undermines religious freedom by requiring Buddhist women to register interfaith marriages in advance. In the event of objections, presumably in the context of marrying a Rohingya Muslim man, the marriage is frustrated. Additionally, in response to public concerns surrounding the Islamization of Myanmar, the Religious Conversion Bill requires converts to secure prior approval from local authorities. UN international human rights experts denounced these discriminatory measures, but the laws were enacted over their objections. In recent years, Burmese officials have also leveraged a national security narrative depicting the Rohingya as a terror threat to the nation's peace and stability to justify abuses that have persisted for decades without acknowledgement or accountability. In August of 2017, for instance, Burmese authorities blamed the Rohingya population en masse for a series of attacks conducted by a meager group of militants on security posts along the nation's border with neighboring Bangladesh. According to the police, the militants from the Arakan Rohingya Salvation Army, also known as ARSA, attacked a number of border guard posts. The group was established in the aftermath of anti-Rohingya violence in Rakhine State in 2012. An ill-armed peasants' militia equipped with slingshots and knives, it is comprised of only several hundred fighters. Burmese officials claimed the group, designated a terrorist organization after the 2017 attack, has a secessionist agenda. In response to the ARSA attack, Burmese officials inflicted horrific abuses against the civilian population, rather than investigate, arrest, charge, and prosecute those violent extremists involved. Soldiers summarily executed those of thousands of Rohingya men, women, and children. Additionally, the gang raped women, destroyed homes, and displaced tens of thousands internally. Burmese officials also prevented international relief agencies from delivering necessary food and medical care to the most vulnerable Rohingya. In addition to the torture, mass killings, forced disappearances, and arsons, the UN also found pervasive gender-based violence. Approximately 52% of Rohingya women reported rape or abuse by members of the Burmese military. Regarding national security or ensuring quote-unquote peace and stability, Human Rights Watch observed, Quote, the Burmese government says its crackdown is in response to a security threat, but what security advantage could possibly be gained by raping and killing women and children, unquote. Significantly, during her reign of power, Aung San Suu Kyi, the human rights advocate who triumphed in the 2015 democratic elections, refused to pursue meaningful reforms to realize Rohingya human rights. In response to related criticism that she turned a blind eye to flagrant human rights violations against the Rohingya Muslims, she characterized the recent humanitarian and human rights crisis as the unintended consequences of necessary counterterrorism measures, rather than part and parcel of a decades-long persecution. She also accused international actors of, quote, drumming up a cause for bigger fires of resentment. In other words, the long celebrated democracy icon provided political cover for the mass atrocity crimes committed against the Rohingya as a political matter of strategic self-interest. In fact, official atrocity crimes against the Rohingya have animated 3 distinct legal challenges. First, on behalf of the 57-member Organization of Islamic Cooperation, the West African nation of the Gambia filed a case with the International Court of Justice, the UN's highest court, accusing Myanmar of genocide. Second, the International Criminal Court authorized an investigation to Myanmar's deportation and persecution of Rohingya, regarded as crimes against humanity under international law. And third, the Rohingya rights organization filed a legal challenge in Argentina against military and civilian officials requesting domestic courts investigate atrocity crimes. These cases, each of which were instituted in 2019, represent the very first attempts to hold officials accountable despite decades-long persecution. It is the first time members of the international community have attempted to hold Myanmar accountable for its international crimes. In the interest of time, I'll discuss one case currently pending, and that's the one before the World Court, titled The Gambia versus Myanmar. On November 11, 2019, the Republic of Gambia filed a lawsuit against Myanmar in the ICJ, also known as the World Court, located in The Hague. The UN's primary judicial body, the ICJ, adjudicates international legal controversies between nations, while also issuing advisory decisions to UN entities regarding international law. The forum provides nations an alternative dispute resolution mechanism to conflict, where the court's findings are grounded in international law. The ICJ's 15-member bench is comprised of judges from countries around the world who serve a 9-year term independently of any government. The Gambia's lawsuit, supported by the 57 members of the OIC, allege violations of the Genocide Convention to which both Gambia and Myanmar are parties. As such, it seeks to enforce Myanmar's obligation to protect the Rohingya from acts of genocide. Specifically, the Gambia relied on Article 9 of the Genocide Convention, allowing any party to the treaty to hold another state accountable for genocide, since all member states have an affirmative duty to prevent and to punish genocide. Interestingly, Canada and the Netherlands have publicly lauded the Gambia's application while indicating their willingness to support its efforts. Additionally, the Republic of Maldives indicated that it intended to file its own related intervention with the ICJ to protect the Rohingya from genocide. So it's important to note that the case involves litigation between member states to the UN who are subject to the UN Charter, the ICJ statute, and the Genocide Convention, rather than holding specific individuals criminally responsible for coordinating, committing, or permitting particular acts of genocide, which is what's occurring before the International Criminal Court. This lawsuit aims to hold Myanmar accountable as a state. Moreover, while some nations have imposed sanctions against Myanmar for its genocidal campaign against the Rohingya, such as the United States, Australia, and some European countries, the ICJ lawsuit represents the first formal attempt to hold the state legally responsible for international crimes pursuant to a major international treaty. A closer examination of the Genocide Convention helps illuminate Myanmar's international crimes and the myriad factors that contribute to state-sanctioned violence against the Rohingya. So what is the Genocide Convention? In the aftermath of World War II, gave rise to an international human rights movement and a global legal regime comprised of treaties in which states committed to protecting individual rights so as to prevent future atrocities. The term genocide, an international human rights instrument that would subsequently define it, dates back to this very period. In response to the horrors of the Nazi final solution, scholar Raphael Lemkin conceived the term to denote an atrocity aimed at the very destruction of a group. The Genocide Convention, the first human rights treaty adopted by the UN General Assembly on December 9th, 1948, subsequently defined genocide as a crime while contributing to the development of international human rights and international criminal law. In the 73 years since the UN General Assembly adopted the Genocide Convention, more than 150 states have ratified it. Article 2 of the convention, which came into force in 1951, defined genocide as, quote, any of the following acts committed with the intent to destroy in whole or in part a national, ethnic, racial, or religious group, including killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on a group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within the group, forcibly transferring children of the group to another group. Genocide is commonly described as the, quote, crime of crimes, and its prohibition is elevated in international law. State parties to the convention must prevent genocide and punish those, including military authorities, government officials, and individuals who commit it. Significantly, Myanmar has explicitly agreed to these affirmative legal obligations since 1956, when it first ratified the treaty. As such, it's subject to the ICJ's jurisdiction since Article 9 of the convention sets it forth as its dispute resolution mechanism. So what is the case for genocide? In its suit, which relies on myriad UN expert reports, the Gambia alleged that Myanmar committed the following acts of genocide against the Rohingya as provided under Article 2 of the convention: killing, causing serious bodily and mental harm, inflicting conditions that are calculated to bring about the physical destruction, imposing measures to prevent births, and forcible transfers. To better understand the nature of these allegations and the myriad factors contributing to the commission of mass atrocity crimes at issue here, a related legal analysis is warranted, including identification of the persecutors, determining whether the Rohingya qualify for legal protection as a distinctive racial, ethnic, and/or religious group, assessing if the perpetrators intended to undertake a genocidal campaign, and evaluating the alleged atrocities. So first, who are the persecutors? According to international law, Myanmar is responsible for conduct that it effectively controls and directs. The country's military and government authorities are responsible for the mass atrocities committed against the Rohingya. As such, Myanmar is criminally liable for their acts under the convention. To qualify for legal protection, the Rohingya Muslims must be a distinct national, racial, ethnic, or religious group. Historically, the Burmese saw the Rohingya as illegal immigrants from South Asia, as I noted, who were allowed in by their British colonizers. Myanmar's authorities have denied them citizenship rights on this basis, even though their presence predates colonial rule. In fact, the country's citizenship law codified the legal exclusion of this group in 1982 by refusing to grant them citizenship while recognizing more than 100 other racial and ethnic groups. Today, the Rohingya are the world's largest stateless community, deprived of legal protection from the government. What is more, Aung San Suu Kyi, Myanmar's deposed leader and Nobel laureate, refused to recognize the Rohingya as an indigenous group with a unique language, culture, and history. Like many Burmese, she said the term Rohingya was inflammatory. Rather, the group is called Bengali and told to return to Bangladesh. Ironically, however, Myanmar's laws, policies, and practices systematically singling out the minority, religious, and ethnic community evidence its distinctiveness as a protected group under the convention. This not only includes denial of citizenship rights, for instance, but also restrictions on religious freedom, forced displacement, extrajudicial killings, among other human rights abuses. Indeed, the Rohingya self-identify as a distinct ethnic group with their own language, history, and culture. The convention also requires that the persecutors have a special intent to, quote, destroy in whole or in part a protected group. Genocide, crimes against humanity, and ethnic cleansing refer to different punishable acts and each have a different mens rea. To qualify as genocide, a crime must be committed with a specific intent to eliminate an entire group of people based on their ethnicity, nationality, race, or religion. International criminal courts and tribunals have confirmed that this list of groups is conclusive. The narrow definition of the crime In Genocide Convention, in particular, the exclusion of conduct committed with the intent to destroy political, economic, social, or cultural groups was influenced by the negotiation process that led to the adoption of the treaty and the need to gain widespread state support in order for the treaty to be effective. Absent proof of this specific intent, perpetrators can still be found guilty of crimes against humanity or ethnic cleansing. Crimes against humanity are widespread and systematic attacks knowingly directed against any civilian population, while ethnic cleansing only refers to the expulsion of a group from a particular area and has not been defined and recognized as a separate crime under international law. There's no precise definition of this concept or the exact acts to be qualified as ethnic cleansing. Ultimately, intent can be difficult to prove without a persecutor's explicit confession. However, genocidal intent can be inferred from various factors such as the broader context, the scale of atrocities committed, systematic targeting of victims, and derogatory language. Indeed, the Gambia's application argues that the following elements of Myanmar's persecution constitute evidence of genocidal intent. Specifically, its systematic denial of legal rights to Rohingya, such as the restrictions on their ability to marry, secure citizenship, or move freely. They also point to the coordination of dehumanization and demonization campaigns year after year. To be sure, the escalation of state-sanctioned violence against the Rohingya is part of a larger pattern of persecution dating back to 1948, as I previously explained, when Myanmar achieved independence from British colonizers. Authorities called them foreigners and denied them citizenship. Since then, Rohingya have suffered mass expulsions, gender-based violence, arbitrary arrests, unlawful detentions, among other human rights violations. For decades, and not merely since August 25th, 2017, Myanmar's Rohingya Muslims have also been subject to the two-child rule, which are laws designed to control the group's population growth. Prior to marrying, Rohingya couples must swear in a signed statement before authorities that they will not have more than 2 children. And if they do, they're subject to blacklists. Additionally, since 1948, systematic messaging painting Rohingya as foreigners, illegal immigrants, and Bengali, more recently as terrorists, create, reinforce, and spread anti-Rohingya sentiment on a national scale. Such derogatory language dehumanizes Rohingya and allows for military and government authorities to justify mass human rights violations against them as disfavored, stigmatized, and a suspect group. Finally, genocidal intent may also be inferred from the scale and nature of atrocities committed, causing almost 1 million Rohingya to flee to Bangladesh since August 25th, 2017. In fact, a related report from the Office of the UN High Commissioner on Human Rights explains credible information indicates that the Myanmar security forces purposely destroyed the property of the Rohingya, targeting their houses, fields, food stocks, crops, livestock, and even trees to render the possibility of the Rohingya returning to normal lives and livelihoods in the future in northern Rakhine almost impossible. Tens of thousands of Rohingya have been internally displaced because of armed attacks and a military scorched earth policy. Further, international humanitarian aid has been blocked, preventing necessities like food, water, and medicine from reaching 250,000 people. Arguably, genocidal intent may be inferred from the totality of these circumstances. Regarding the killing of members of the group, the convention specifies killing of protected group members as genocide. While the murders need not be premeditated, it must be intentional to trigger criminal liability. According to NGO reports, the military's atrocities have in fact left tens of thousands of Rohingya dead. The convention and case law developed by the ad hoc international criminal tribunals have defined causing serious bodily or mental harm to members of the group as encompassing torture, cruel and degrading treatment, persecution, and gender-based violence. Again, committed with the requisite intent to destroy the protected group. Since August 25th, 2017, government forces have assaulted, raped, and tortured Rohingya, inflicting both physical and psychological injury. According to humanitarian aid agencies in Bangladesh, more than 350 Rohingya have received life-saving care relating to gender-based violence. What's more, UN medics report that attacks by Burmese forces against women are more aggressive. A refugee in Bangladesh told Human Rights Watch that the army attacked her village in August of 2017, setting buildings ablaze while murdering people. They forced her and other women to watch as soldiers burn lifeless bodies. When she attempted to hide her infant daughter beneath her clothes, a soldier threw her baby into the fire. The soldiers also killed other children and raped her. Lastly, regarding deliberately inflicting on a group conditions of life calculated to bring about its physical destruction in whole or in part. This third category of genocide includes acts that may lead to the slow death of the persecuted group. Many of the atrocities described above may similarly fit here as well, including systematic expulsion of Rohingya from their homes and deliberate deprivation of humanitarian aid like food, water, and medicine. Imposing measures intended to prevent births within the group for decades and not merely since August 25th, 2017. They've been subjected to the two-child rule, which are the laws designed to control the group's population growth. Prior to marrying, as I mentioned, Rohingya couples must swear in a signed statement that they will not have more than 2 children. In the interest of time, I'll stop there. I will mention that after instituting this particular lawsuit with the World Court, the Gambia also made an application for provisional measures, which is the equivalent of asking for a restraining order against another member state. And that application was granted against Myanmar to cease all further genocidal acts as the litigation unfolds. In addition, they have to try to control non-state actors such as militia groups and prevent them from engaging in any physical, mental, or other harm against members of the Rohingya population. They're also barred from destroying any evidence that might be used during the course of litigation. So as a preliminary matter, that was considered a huge victory for the Gambia, and moreover for the Rohingya, where 1 million refugees continue to reside in Bangladesh. Thank you.
Thank you so much, Angie. That was compelling and really such a wonderful overview. We appreciate it. So I know that we're at the very end of our time, but we do have a couple of questions in the chat. So for those of you who are able to stay on a little bit longer, let me just throw them out. One of the questions was about why the international community is not taking any stern action against the authoritarian regime. We've now learned that there have been a number of actions taken. I think that one of the challenges is the constant challenge of enforcement of international human rights laws and the mechanisms that exist for that enforcement. A second question has to do with whether there are any cross-sectional, either religious, ethnic, or class coalitions within the current pro-democracy movement, or whether this really is a movement of the majority of the Myanmar majority. Angie, do you want to address that question?
So I'm actually just checking are there any cross-sectional religious, ethnic, class coalitions in the current pro-democracy movement? So I think that's more in light of recent developments since the coup. And my observation regarding that is, unfortunately, while Aung San Suu Kyi has been widely heralded as a democracy icon and champion of rights for all, I think she really failed in terms of ensuring equality and the preservation of rights with respect to the Rohingya. I think there is some commentary in terms of the fact that she may have done that because she was afraid of this very result of a coup by the military. And so for political reasons, she chose to remain silent and provide that political cover for the atrocity crimes that were committed against the Rohingya. And I think it speaks to the earlier question about why haven't we seen more action from the international community. And it's interesting, I work currently with the Department of Political Science at Rutgers. And so, my instruction often focuses on the role of politics. And I think that includes the role of politics in legal proceedings and legal interventions. And I think it helps explain some of the complacency and the lack of legal intervention up until very recently, the 2019 litigation that we've seen unfolded. And so I think it's important to recognize that. So I think whether the military is in power, it bodes poorly for the future of the Rohingya, but so did the rule of Aung San Suu Kyi. And again, I think that's very much for political reasons.
Yeah. Holly, do you want to weigh in?
Yeah, no, I would love to. You know, on the question of sort of, you know, why isn't the international community doing more? You know, I think in part it's really tough. Sort of what we're seeing, you know, from international stakeholders on the ground in Myanmar and donors and funders for international development work, rule of law work, is that you know, really that's the main way that big states and international and countries kind of do anything impactful, is with money. And so the fear is, though, that if with sanctions, you know, that are targeted against the military regime, you know, that needless others suffer as a result of that. And so there's a lot of politicking about how the international community can both, you know, sort of punish or come out against the junta, but also, you know, keep supporting civil society and the pro-democracy movement. And that's challenging. You know, something that happened, I think, yesterday, which was, I think, a terrible kind of stain on the international community. There's a big international conference held by the United Nations, the Crime Congress, happening in virtually, but being hosted by Japan at the moment. And they actually let the United Nations envoy under the military speak at that conference. And there has been quite a bit of kind of outspoken backlash around that. You know, the prior, or the UN representative under you know, the NLD government made a big, very, very moving speech at the United Nations a few days ago, and the military then you know, sort of kicked him out. And you know, how much that stands now, I don't know, but I guess the United Nations is sort of saying they recognize this new military representative. I do also want to say, I mean, to the extent that you can kind of Google and follow what's going on, the amount of diversity in terms of people on the streets protesting has been really just, I think, fantastic. I mean, you're seeing people from all walks of life and all groups out in you know, massive numbers. Rohingya communities and Rohingya groups marching in Yangon against the coup. You know, a big, you know, you've got a huge women's movement, and there was an article in the New York Times, I think yesterday or the day before, that really highlights just how amazingly brave and forceful the women activists have been in Myanmar throughout this process. You know, there's huge LGBT movement, you know, in Myanmar as well. And so you've got drag queens, you know, marching in protest as well. There's, you know, a lot of ethnic communities. There's really a vast number of ethnic minorities in Myanmar. And, you know, to some extent, I think that there has been a really big sort of groundswell of involvement and engagement, despite the very real and very dangerous risks. I think Laura is
I
frozen.
think I'm frozen.
Oh, there you're back. Wait.
Okay, good.
I can hear you at least.
All right, that's good. Sorry about that, guys. It's the perils of Zoom. So I just have one last question before we this very, for lack of a better word, and it's not enough of a word, complicated history. What should the international community be supporting? So supporting a return or reinstallation of the civilian government without demanding greater protections for the Rohingya people, would that be is that the moral stance that the international community should take? Should we be grabbing onto this moment and using it as, and I think this goes to the questions that have been put in the chat, as leverage for a demand for change in the country? What is the principled and necessary stance that the international community should be taking at this moment?
So, I think that's a really interesting question. I'll say I want to sort of piggyback on some of the comments that Holly made earlier regarding the role of money and sanctions. I think consistently the international community has responded to the what they have commonly termed as ethnic cleansing and crimes against humanity, and maybe a little bit more recently as genocidal acts against the Rohingya community, vis-a-vis sanctions. And we've seen this consistently from the United States, as well as partners in the European Union and elsewhere. I think we've also seen there's been a huge commitment of financial aid in terms of humanitarian assistance to alleviate the humanitarian plight of the Rohingya during these various waves of ethnic and religiously motivated violence, whether in 2016 and 2017, so on and forth. For example, the U.S. has committed $1.5 billion in humanitarian aid to assist the Rohingya, and so have other governments around the world. I think one of the frustrations I have watching this unfold is that while that's to be commended, it doesn't speak to the root causes of what is actually contributing to the violence and the persecution of this population, which essentially is inequality, and that's perpetuated, for instance, by these codified measures, such as the 1982 Citizenship Law that prevents the Rohingya from securing citizenship. And by virtue of depriving them of that lawful status, they're unable to secure equal access to healthcare, to educational opportunities, to employment. They're unable to move freely in the country, and they're made more susceptible and vulnerable to other human rights abuses, such as the arbitrary deprivation of life, such as unlawful detention, such as torture, so on and so forth. And so, in response to the recent military coup, I think President Biden actually signed an executive order seizing some of the assets of the military to sort of incapacitate them and to pressure them to succumbing to democratic governance. But in terms of the plight of the Rohingya, their suffering continues, the persecution continues. And so I think while this litigation is to be welcomed, whether it's the case instituted by the Gambia before the World Court, or the investigation into crimes against humanity in the International Criminal Court, or this other lawsuit in Argentina, international community, I think, has failed the Rohingya population. And some have asked why, there haven't been other executive orders pressuring Aung San Suu Kyi when she was in power to ensure and uphold the human rights of all those living within the boundaries of Myanmar, including the Rohingya, particularly given the credible reports of genocide by experts around the world, including with the UN. So I do think there needs to be a consistent approach where the rights of all are recognized and upheld, and not simply one that's more selective in nature.
Thank you. So we are at 1:30, and I think we have to stop now. Thank you both so very much for sharing your wisdom and your insights with us today, and for helping us all learn more about this situation as it keeps unfolding. I would encourage students who are here to keep reading and keep this discussion going. And I'm sure that either of our speakers would welcome, I'm putting them on the spot here, but welcome any reach out from them. And I guess that's it for this afternoon. Thank you both so very much.
Thank you, Laura.
Bye.